commissioners were giving you an opportunity. Have you located what you're looking for?
It triggers. It triggers the recollection, and I'm going to hold you to. I'll have to come back with the chapter and verse.
Okay.
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget, and the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, asked to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully.
That is correct.
So she would violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Kumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role. If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
isn't.
They are
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment, and because of the fact that from previous matters, not in IDAC, that is how funds were looted, out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being, if I may come in, no. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her in the future, no harm. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you.
In what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
In that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025, this is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDAC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand investigation have to be properly revisited.
I think the vetting issue in respect of Ms. Mukwele, we can put that to bed.
That is it.
Colonel Padiaki accepted that the way CI did it, the way the panel did it, disadvantaged Ms. Mukwele. It did not benefit her because the requirement said she must subject herself to vetting 6 months after the appointment. So the fact that they were doing it before the interview was in fact disadvantaging her, not benefiting her. I think with Colonel Padiaki, we settled on that and he accepted.
Yes, I accept that. I'm saying with all other, the averment of persons not suitably qualified and or experienced, and or with regards to vetting, if they still find place in those other investigations not yet completed, those would have to be looked at as a matter of urgency and dealt with.
I don't want to force you to concede that, because the other people, the process of their vetting was different.
Yes.
With Brigadier Mukwele, the requirements were clear that it must happen 6 months, within 6 months after. So the other people that you referred to in your summons, I'm not there yet, so I don't want to force you to concede that.
Thank you, Commissioner. It's not a concession. It is a matter of saying, I have heard the argument and I should reapply my mind, given all of the discussions that were raised.
Your response to Commissioner Kumalo that if a candidate meets the requirement, then there couldn't be gratification. I don't know that that is correct in your present case, that kind of answer, because gratification is a quid for a quo.
Yes.
So the way you have constructed the charges against Ms. Mukwele is that she was given the position so that she can do something. So she's been rewarded with a position to do something. And that's something you have described it as capture of crime intelligence. You have described it as such. So it seems to me that on the case that you have, it really doesn't matter whether she met the requirements or not, your case is this is a preca offense. They have appointed this person so that they can siphon off funds. That's Mr. Adams's complaint, which you have agreed with in the formulation of the charge. So and I don't expect you to do the same thing that Colonel Parachi did, which is, well, we don't know what the offense in the future will be, whether she will commit it or not. But the charge itself would have required you at day one to say, and maybe you do have that. I'm not getting into the merits of whether you have a winnable case or not. I'm speaking at the starting point is you formulate a charge, and if the charge is giving someone employment, that's one form of gratification. It's employment in return for something. That provision in PRECA doesn't say someone who's not qualified.
Correct.
It doesn't. So she may well be qualified, and yet she gets appointed precisely so that she can assist to achieve certain ends. So your concession that you are easily making now, that, well, if it is a qualifying person, there could not be an offense of gratification. The offense is not just the appointment.
Yes.
The offense is you get appointed because you're going to give something.
Yes.
In return. So your answer, you have to amend.
Yes.
Your answer to Commissioner Kumalo.
The answer talks to the suitability in terms of the appointments and whether or not the vetting processes were met. The additional issue, if in fact related to all and not just to Mokwele, would have to be looked at differently. The appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later on. I have to see what that investigation says. I cannot tell you that there is in fact evidence that there is collusion. The concession I make is that with regards to suitability, the standing instructions, and the vetting process, those are the matters that I would look at. And
no, I'm not raising with you, certainly not raising the vetting issue. I'm raising a narrow issue with you, which is your answer, your concession to Commissioner Kumalo suggests that you accept that because if it is found that she met the requirements, then we were wrong to claim gratification, that this is a PRECA offense, which is a gratification offense. I don't remember the exact wording of that provision. I'm saying your answer, to the extent that you're saying, well, if she did meet the requirements, then we are wrong. I'm paraphrasing. I'm not saying that's what you said. If your answer is because she meets the requirements, or if it is found that she met the requirements, then we couldn't speak of gratification. I'm saying you are wrong, because that's not what that offense is about. That offense is you will prove in court that her appointment, it so happened that you say she's not qualified, and you say she's appointed even though she's not qualified, but in court you will show that this appointment, qualified or not qualified,
notwithstanding, is a gratification.
It's a gratification for what she's going to do. You understand the point?
Yes.
I'm making? You agree
that does not fall away.
You agree with my construction?
I can't agree with your construction. That's not a concession. It is the
5.3.
Yes.
I was not going to the offense in section 3 of PRECA, which is what Commissioner Baloyi is engaging you on.
Yes.
So the answers to both our questions may be different.
I understand, and I didn't assume that you went beyond
Yes,
just
I
the suitability.
deliberately avoided going to the charges. I was just sticking to your statement.
Yes, I accept that.
Thank you, commissioners, and thank you, Advocate Johnson. For my edification, 25.3, does it apply to Mrs. Mokwele? Or do you think it could potentially exclude her because she might be suitably qualified? How do I read it? How do you suggest I read it?
So we have agreed, counsel, that she is suitably qualified.
So therefore, the remainder of 25.3 doesn't apply to her.
She's suitably qualified and experienced. The appointment of persons not suitably qualified and experienced as a form of gratification for that doesn't exclude that part of why she was appointed, even though she's suitably qualified. Yes.
So then she is not out of the woods yet, because if you are to concede that she could potentially be suitably qualified and experienced, her appointment in and of itself is gratification for her collusion later in the looting of state funds.
That is correct, yes.
What in the investigation leads you to believe that in the future she will collude in the looting of state funds? Something in that investigation must have pointed you out to this. What could it potentially be?
So the information that we had at the time was that in the process, she would have been part of a process where monies would have been taken from the secret funds in order to purchase properties, and that her placement there would have assisted that process. That was the contention or the allegation.
As a mechatronics, whatever. I'm trying to understand. I hear what you are saying is restating what is contained in 25.3. You're not giving me a basis for that conclusion. You're already concluding that she will be involved by virtue of occupying that position. And I want to understand what in the investigation leads you, by you I mean IDAC, to conclude that you give her that job, she's in the Secret Service Fund, and therefore she will be looting state funds to pay. She'll be colluding, I correct myself, I don't know with who with, but to loot state funds and purchase properties. What in those files should we look out for to support the conclusion that you draw, the fear that you express at 25.3?
I'll just have to be given an opportunity to go back and to look into the evidence.
No, you must have had it. For you to submit on oath, you confirmed the correctness of this statement when we started. So you must have an idea, and I suggest that perhaps you start sharing it with us. Might not be firmed up. When you return, you will give us the full now facts, chapter and verse. But for now, when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
Commissioners, I ask for a moment.
Yes, please.
Exactly, and yes, and so in the end, fairness and justice must prevail. So if we have made the wrong decision, then that decision will be corrected. And I'm saying that in terms of the appointment, I'm not retracting anything that I said at all.
I think my difficulty with you is if you should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute, if those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions. It's not about the merits of your case, and I think we may not have fully succeeded to steer from talking to the merits, because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a predicate offense of gratification, but not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mukwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur with the charges, they are good, what were they working off? So we're still at first base, before representations and before a review. Where does this all come from? Right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the statement, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision not based on any facts. And because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have that to ask the question, what was the purpose? I hope you understand. What I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace that, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this and the prosecutor and all the people that I've listed to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDAC witnesses, we will find out what was the purpose. That for me is the real issue here.
For what is stated in that paragraph. No factual basis.
And so I'll take it then, it's a conditional deletion for now, depending on what you unearth. in your investigation records.
Only the latter part.
The latter
There's
part
no
of that
evidence,
paragraph.
yes.
The first is already fallen away. Now, you say by Lieutenant General Khumalo, he's the head of crime intelligence. He's got access to the very funds that you speak of. Why does he have to go through all these hoops to access the funds, as you suggest? As if he is outside crime intelligence. He heads it. He's responsible for that budget.
He doesn't have direct access to the budget. He has to work through the co-accused.
And they all account to him.
No, sorry.
Sorry.
I was just trying to get to I think he must be Lieutenant General Lushaba, or is he Major General Lushaba, but the accused General Lushaba. That is where that point relates to. So whilst General Khumalo, Lieutenant General Khumalo is the head of CI, he does not have direct access to funding. He has to work through the CFO, who is General Lushaba.
So that then, okay. The thing is, they all account to him. So then, on your theory, they must all be beholden to him, which would mean everybody in crime intelligence, because they are beholden to General Khumalo, will in the future collude, I don't know, perhaps with him or whoever, to loot state funds. That theory must apply to everyone who eventually accounts to General Khumalo.
Incorrect.
Okay,
I say that
If the charge of gratification is indeed a valid charge against any one of them, and with Lushaba you say the gratification is there was no disciplinary action taken against him and therefore he would have to do something in turn, he must be charged. He must be charged with that offense because he received gratification. It's not just Ms. Mukwele. Whoever he's going to be doing favors for must also be charged because gratification is a two-way street. And so there must be two people charged for this. Whether it's General Khumalo, whether it's his boss, the question remains is you allege gratification, the failure to discipline. You say that is gratification to someone who is strategically placed, who will assist to loot. And I'm saying, well, are you charging anyone with this gratification? You say not General Khumalo. My question is, are you charging anybody? And if you're not charging anybody, my question remains, well, it's a predicate offense according to you to loot crime intelligence funds. Why is no one charged then for that future offense that might happen, might not happen?
I have to come back to you because I've got to go through the charge. I'm not sure that no one is charged,
Okay.
or I'm not sure who is charged.
Okay.
But either way, your question, I understand it.
All right. No, so I accept. Go look it up, and then you'll come back and tell us who's being charged with this. But I want to leave it with this proposition that if no one is charged for this, no one at all, one. Two, if whoever was his superior at the time that this incident happened is not charged, and
Why not?
subsequently, why not? But also, it seems it would suggest preferential treatment, that there's no consistency in how you treat offenses. Some you charge for gratification, others you don't. That's where I'm coming from. So when you look it up, prepare that we'll have further discussion along those lines.
Okay.
Thank you.
Thank you, Commissioners. Chair. The referral affidavit, Mr. Adams says it's at file 2, page 512, and the paragraph you're referring to is paragraph 3. File 2, page 512.
Yes, that is.
Now if we go to 513 at paragraph 3, he says, my suspicion about General Khumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So, if I understand you correctly, within the engagement yesterday that there were no grounds, you said that is one of the grounds. Now, you haven't seen the content of the envelope, and the documents therein, but you rely on Mr. Adams, who says, trust me, I've read them.
That is correct.
Okay.
Can I just on this, follow up on this? I don't remember which provision exactly in the NPA Act, but there is a provision that states that if in the course of your investigation you come upon, I'm going to call it information because I don't remember the exact terminology of a possible offense, another offense that is not what you're investigating, you can refer it on if it's not part of what you're investigating. Am I correct in remembering such a provision? Yes. Now, on this here, in the referral affidavit, Mr. Adams tells you that I have intelligence documents that were shoved under my door. And from those documents, I have even more reason to believe that Kumalo and them, General Kumalo and them, have committed offenses. Isn't that typically, because you know, you are in the sector, you know that when he says somebody shoved intelligence documents under me, it's material that he shouldn't have. You know that.
Correct.
Did you do anything in accordance with the provision of your act that says if you come upon information that suggests a possible offense being committed, you refer it to another agency? Did you refer this possession of intelligence documents that were on Mr. Adams's own account were not properly given to him or lawfully given to him? Did you refer it to the appropriate agency for investigation?
I did not, Commissioner, not having any knowledge or sight of the documents he referred to.
He tells you that he's got documents that speaks to intelligence matters. It's crime intelligence documents about procurement and something else. You have acted on his intelligence documents. Documents that someone gave. That seems to me a classical case of you should have referred this to somebody. You don't need to see the documents to know. He's telling you I've got possession of those documents. Why did you not consider it a case that must be referred to somebody else to look at, the appropriate authority to look at?
I did not.
Okay. And you don't have a reason why you didn't do it?
No, ma'am.
Okay, thank you.
Thank you, Commissioners. Your October 25 statement to the Commission regarding the dockets. Now, this says, I do recall having written to Lieutenant General Sintumule, and I recall her then ensuring that the dockets were received accordingly by IDAC. Up until yesterday, your testimony was that you requested these documents from Major General Kumalo, and you clarified not Dumisani Kumalo. I think you provided another name. Mbuso, thank you, Commissioner. Mbuso Kumalo. Please explain. You say from General Sintumule, you say to Major General Mbuso. Who did you request these dockets from?
So at the time, Commissioners, my recollection was my letter to General Sintumule. Sorry, Chair. At the time, my recollection was my letter to General Sintumule. I had subsequently, but well after ad hoc, the investigation team advised and in fact showed that we had first written that morning to General Kumalo of Gauteng, the detective head. And on the same day, a letter followed to Lieutenant General Sintumule as the Divisional Commissioner of Detectives.
Why to both?
When the letter was written to General Khumalo, it was because Adams had indicated he had opened dockets in Orlando, Chair, that falls under Gauteng. So we had to write to the commissioner. And he indicated, if my memory serves me correctly, he indicated to the investigator, either it's Mr. Rapes or Mr. Perumal, that the dockets were no longer with him and that the dockets were with the inspectorate, if I recall the feedback correctly. That would be the inspectorate that we're referring to in terms of where General Jacobs was the head. I then write to the Divisional Commissioner of Detectives, Lieutenant General Sentumule, as the national custodian of the dockets. And General Sentumule facilitated the receipt of those dockets. Those dockets were then, in fact, commissioners and council found to be with Lieutenant General Peter Jacobs and were then handed over.
So Mr. Adams would have told you on the 6th itself, because you wrote to General Mbuso Khumalo on the 6th. But on the same day, you write to General Sentumule for the explanation that you've just given. It must mean, therefore, that after writing to General Khumalo, even before he responded to you, you were in touch with Mr. Adams about these dockets, and then he told you then that actually they are with the inspectorate. Is that how it happened?
No, Commissioner Baloy. In his affidavit, the Section 27 referral, he initially in paragraph 1 refers to the dockets he opened in the Western Cape. And thereafter in paragraph 8, he says, a few days after I opened the 3 cases at the Cape Town police station, I decided to go to Gauteng. And I went to Orlando police station where I opened another 3 cases based on the 3 cases I had opened in, and that is where we got it from, that he had opened cases again in Gauteng.
I understand that. And unless I misunderstood you, I understood you to say to Ms. Sello that you wrote to General Khumalo requesting the dockets after because you're relying on the Section 27.
That is correct.
So you write to the Gauteng head, General Khumalo, to give you these dockets. This is on the 6th of December.
Correct.
Yes. But on the very same day, you write to General Sentumule now at head office, even before you get a response from General Khumalo. And I understood you to say you wrote to General Sentumule because Mr. Adams told you that the dockets are with the inspectorate. Did I understand your evidence correctly? Or did I hear it correctly?
Commissioner, we wrote to the provincial head, Major General Khumalo. He had informed the investigators that the dockets were not with him. It is on that basis that we then made the follow-up on where the dockets were. Now, I'm not sure whether it was Investigator Rapeso or Investigator Perumal who subsequently found out that those dockets were with the inspectorate, which is why I then wrote on the very same day. But they had got a response that it is not with Major General Khumalo.
All right, and that response, they didn't get it from Mr. Adams. I had misheard you then.
You misheard me.
Okay, thank you.
Thank you on that. So you wrote topic, and in fact, if you go to MK15 at page 295, that is part of a document from legal services, SAPS legal services. That's at 293. I'm particularly interested in 295, paragraph 4. And you say you never became appraised of the contents of the dockets. So at paragraph 4, the author of that document, Lieutenant General Kamani, states, Only the complainant's A1 statements are contained in the 6 dockets. No other evidence is contained in the dockets. The lack of location information makes it impossible to determine proper jurisdiction at this stage. Let's jump ahead to 296. At paragraph 13, the current information contained in the dockets is scanty and too vague to formulate charges against any suspects. As a result, legal services is unable to confirm that the required elements of any offense are contained in the dockets. In light of your admission that you never saw the contents of the dockets, you can't take issue with these findings.
I cannot.
You have to accept them.
I cannot take issue with these findings. Safe to say, when he makes these findings, he didn't have a section 27.
Now, I assume it's a he. His analysis of the contents of the docket. That's all I'm interested in. So as far as he's concerned.
I can't take issue with his analysis, Chair.
But based on the engagement we had yesterday, the Section 27 referral affidavit could not possibly have made any difference, even if the writer of this legal report had sight of it. It would not have made any difference. I say that because when I engaged you yesterday, you accepted that there was nothing there. Do you accept that?
I accept the point.
Thank you.
Thank you, Chair. Might this be an opportune time for a tea adjournment? Top.
Is signed on the 30th of May.
Yeah, okay.
And the designation for the persons who are to deal with it are on 3303.
I accept your point, correct? So the first designation is 3302, that's dated the 30th of May 2025.
That is correct.
The document I looked at, you say, was adding to the designated team in August.
As happens in all matters, if you add persons to an investigation, regardless of who they may be, you must designate them to the investigation.
I'm with you. I accept
and
that. Thank you.
Just for context for why there is a later one.
Thank you for that clarification. Then,
sorry, I think Commissioner Khumalo has a...
Oh, yes, please.
I think it's confusion more than anything. I had understood during your first day of testimony that the designated investigator came to you in February to say, please authorize summons so that we can get these documents in relation to the generals that appear in those summonses. And that was sometime in February. There was also a summons that went to BMW again in February. Now, they could not do that unless they were designated as investigators, because for them to say, I need to go into BMW and get documents and interview BMW people, because that's what the summons said. And that was all in the first or second week of February. That can only mean there must have been an earlier designation appointing them as investigators, because if the designation only happens at the end of May, what were they doing talking to BMW management in February of 2025 and interviewing senior managers at BMW in February 2025? So do you see why I'm lost?
May I explain?
Yes.
So, Commissioner Khumalo, when the Section 2813 preparatory investigation was authorized on the 6th of December, it also designates persons to the investigation. And because they are designated to that preparatory investigation, they are able to conduct investigations.
May I assist? Please answer that question with reference to page 3282. Same file. You say with the Section 2813 preliminary investigation is authorized, it also designates persons who should conduct the investigations. And that is the document we discussed from yesterday. That is your authorization.
Yes.
And it's followed by 3285.
Yes,
You say that's a designation in terms of 2813. Is that the document you reference?
that is
Dated the
correct.
6th of December 2024.
That is correct.
With those documents, then you may respond to the Commissioner's question.
On page 3286, Commissioner Khumalo, is the list of persons that were designated on the 6th of December, so that there are persons designated to conduct investigations. And as I indicated, Section 2813 does allow you investigative processes, including being able to interview a witness, subpoena documents, and so on.
So there were two designations / authorizations.
Yes, the first being preparatory, and once that is summarized and done, they then bring together the May application.
Advocate Salom covered. Thank you.
Thank you.
Have I clarified it, Commissioner?
You have. Thank you.
While I hope you have your act close by, as we're giving you an opportunity, have you located what you're looking for?
It triggers. It triggers the recollection, and I'm going to hold you to. I'll have to come back with the chapter and verse.
Okay.
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget, and the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, as to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully.
That is correct.
So she would violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Khumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role. If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with
Yes.
the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment. And because of the fact that from previous matters, not in IDAC, that is how funds were looted. Out of accounts where the funds are within a COVID environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come in, no. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her in the future, no harm. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is
It governs how panels are set up, who recommends, who approves. It governs how candidates are interviewed and scored. It governs how the recommendation to appoint is then made and who recommends and who appoints. But your investigators say nothing about this. In fact, they pay no regard to it, because even the definition of what is appropriate management experience, not management position, don't confuse the two. Appropriate management experience, the only place where you find that definition is in this document.
okay.
And your investigators, for reasons that are not clear to me, paid no attention to this and proceeded instead to target a civilian and deal with her in a manner that I have serious difficulties with. So going back to the affidavit, because it goes together. So let's go back to the affidavit. It goes together with the cover page, because the cover page on 682 is described as the statement. And the reason why you have an affidavit is because everything Mr. Adams wants to say cannot fit in this page, on this page 682. So the affidavit has to be an annexure to this page, which says South African Police Service statement, and then has description of the offense, where the offense took place, what the offense is. So if you just look at the particulars of the offense, it says the date of the offense is October 2024. Do you see that?
I see that.
So there's a specific date. And then it says the scene of the offense. It says it is at Crime Intelligence Offices, Priska Street, Erasmus Kloof, Pretoria. Do you see that?
I see that.
So that's what Mr. Adams limits himself to, because this document gave him options. You will see when it talks about date and time of the incident, he could have chosen the starting point and the end point, but he limited himself to a particular date. And then same with the scene of the offense. It gives him the option between, did it start in Cape Town and continue and conclude in Pretoria? But he limits himself to a particular date when a particular decision was made, and he says, that is the offense, that is the date of the offense. It took place at Crime Intelligence Offices. Do you see that?
I see that, sir.
But IDAC's investigation goes to April, it goes to May, it goes to June, and it targets this individual civilian in circumstances that are simply not justified by the referral or the statement or the affidavit itself.